You ride the tilt-a-whirl, you scream, you laugh, and then somehow your neck feels like it went through a blender. That is the exact moment a personal injury lawyer starts perking up like a meerkat, because amusement park cases are a whole weird little universe of law. Here's the twist though. You cannot just sue the funnel cake stand because your stomach hurts. Courts want proof that somebody was careless, not just that carnival food is a war crime against your digestive system. So the first big question in any fair or carnival injury case is who actually owned or ran the ride. Sometimes it is the fairground itself, sometimes it is a traveling ride company that shows up for one weekend like a caffeinated tornado and then vanishes to the next town. That matters a ton because you might be dealing with 3 or 4 different parties at once. The landowner, the ride operator, the manufacturer of the ride, and sometimes even the inspection company that gave it a thumbs up a week earlier. Lawyers call this figuring out liability, which is a fancy way of saying whose fault is it really. Think of it like a game of hot potato, except the potato is a lawsuit and everybody is trying to toss it to somebody else. Now here's where it gets almost detective movie style. Investigators pull maintenance logs, inspection records, and sometimes even bolt-by-bolt assembly instructions to see if the ride was set up correctly that day. A shocking number of these cases boil down to human error, not some cursed machine. An operator rushing to load one more group before a storm hits, or skipping a safety check because the line was 45 people long, that is often the real villain. There is also this idea called premises liability, which basically means the property owner has to keep the place reasonably safe for guests. That covers slippery walkways, busted stairs near a haunted house, or that one exposed wire nobody bothered to tape down since 1998 apparently. People often assume signing a waiver at the ticket booth means they can never sue for anything ever. That is actually a myth, because waivers do not protect a company from gross negligence, they just cover normal reasonable risk like getting a little dizzy on a spinning ride. Regulation is another wild card, since some states treat amusement rides like mini roller coasters of bureaucracy with strict inspection rules, while others are shockingly loose. This patchwork means the exact same ride could be inspected every single day in one state and almost never in another. Evidence in these cases is often a race against time, since rides get dismantled and moved the very next day. That is why injury lawyers move fast, sending investigators, photographers, and sometimes engineers before the cotton candy stand even packs up. Money damages in these cases usually cover medical bills, lost wages, and pain and suffering, but severe cases can also include long-term therapy or permanent disability costs. Juries tend to take these seriously because everyone has been to a fair and everyone secretly wonders if that ride looked a little too rickety. One quiet lesson in all of this is that preparation beats panic every time. Taking photos, getting names of witnesses, and getting checked by a doctor immediately can make or break a case months later. The bigger truth is that fun and safety are not opposites, they are supposed to be a package deal. When companies cut corners, the law exists precisely to make sure screaming from excitement does not turn into screaming from something a lot worse. So next time you're eyeing that giant Ferris wheel wondering if it is held together by hope and duct tape, remember there's a whole legal system quietly watching too. Want to learn more about how we help people navigate cases like this? Check out our links in the description.